and welcome to the firm. On the show this week, India's first 1% versus 90% battle. 95% market share, yes. Cartelization, no. Let's get to the top story first. Never before has India seen a David versus Goliath battle of this nature. In classic terms, it's a shareholder versus the company promoter and management. In modern parlance, it's a 1% versus 90% fight. UK-based hedge fund TCI has filed a representative action in the Kolkata High Court against Coal India, its management, directors and majority shareholder, i.e. the Government of India. Now, this is the third salvo TCI has fired as it attempts to protect its 1.01% equity stake in the world's largest coal-producing company. Paiswani Upadhyay has more.
The first warning came in March this year when the Children's Investment Fund wrote a letter urging Coal India's board to fulfill its fiduciary duties. This was in response to news that the government was pressurizing Coal India to sign a swathe of fuel supply agreements at terms disadvantageous to the company. Then, in April, in a press statement, the fund said that it has directed its lawyers to launch legal action against Coal India's board for allowing the company to be run in a manner that's prejudicial to public interest and oppressive to shareholders. Sensing chances were bleak that the board would heed its warning, TCI this month filed a representative suit under Civil Procedure Code in the Calcutta High Court against the chairman and managing director of Coal India and its 11 board members.
The Civil Procedure Code does allow representative actions on behalf of third parties. In the context of company law, quite often you have shareholders filing representative actions or derivative actions against the board in circumstances where the wrong has been committed by the board itself and therefore the board is not going to take any action, and in that situation the law steps in and allows a representative action or a derivative action, as it is quite often called.
If the court is satisfied that the subject matter of the suit is such in which a sufficient number of other persons have the same interest, then ordinarily the court will allow the plaintiff to turn this into a representative suit. As I said, there are certain rules which will apply, like you cannot withdraw without the permission of the court, you cannot settle the matter, etc.
It looks like it's partially a derivative claim. There is a claim made by them on behalf of the company because the first financial claim is sought on behalf of Coal India. And it's partially a personal action because they're seeking a decree in their favor for loss suffered by their own shareholding.
TCI has pegged this financial loss for Coal India at over 2 lakh crores and its personal loss at over 9,000 crores. It argues government interference in fixing the price at which Coal India could sell coal, signing fuel supply agreements at a price lower than the cost of imported coal, failing to take steps for increasing coal production and missing the targeted production, inaction on setting up of coal washeries that will help generate profits and save costs, theft of coal from Coal India and its subsidiaries, failing to raise objections to the draft mining bill that seeks to introduce a 26% coal mining tax. By allowing all of these, TCI says Coal India's board members breached their fiduciary duty of care and failed to protect the commercial interest of the company.
Certainly there are a couple of mitigating factors in favor of the government. The first and the most obvious one being, if there has been such a huge monetary loss, the government holds 90% of the shares, so who's lost more? The directors themselves have not personally benefited from any of their actions. Have the directors actually exercised their discretion, or have they simply paid obedience to the directions of the government? There is the business judgment rule which makes it very clear that, look, courts cannot intervene in commercial decisions, in decisions which are taken by executive management, unless it's a legal issue. They are not meant to second guess commercial issues. And therefore directors can, certainly use the business judgment rule as a defense in terms of any argument. And then of course, finally there is, the rule that, look, the company is the proper plaintiff, and therefore are these particular shareholders even entitled to bring this suit? And I'm sure during the course of the trial, this particular issue will also come up.
There is a whole lot on neglect, lack of planning, lack of proper husbanding of coal resources, lack of adequate production facilities. Those are more acts of omission in that sense, and that might be, you might have to reach a rather high level of dereliction of duty before you can claim monetary relief on that score. But the question of pricing and deliberately fixing coal below its commercial price could lead to a factor which might give rise to a right and relief in favor of TCI.
Or will it? Because the government is likely to remind TCI that Coal India's draft red herring prospectus at the time of IPO flagged off several of these issues. The risk factors in the DRHP say that there may be a conflict of interest between the government's and shareholders' interest, and that the government, via a presidential directive, may direct the company to conduct its business affairs in a particular manner.
Memorandum and Articles of Association are a public document. They expressly contemplate the issuance of such directives. They expressly contemplate that such directives are binding on the directors. So an investor, particularly a sophisticated investor, comes with full knowledge naturally of these public documents. And even the risk factors, it's not a worst case scenario. It categorically mentions not once but several times in the prospectus that this is a very real possibility that in the public interest, for protection of the power sector and for various things, the government of India may interfere, and that interference may conflict directly with the interests of the other shareholders. Nothing can be more categorical than this.
Coal India produces over 80% of India's coal, and 66% of power generated in India is coal-based. And so, when earlier in the year, Coal India's board differed on signing fuel supply agreements with power plants on grounds that the terms were disadvantageous to the company, the government issued a presidential directive ordering Coal India to sign the FSAs, citing substantial public interest as the reason.
The first point is that, look, is the presidential directive, does it have the force of law or not? And frankly, if it does, then clearly the directors have a very good escape route by saying that, look, we were acting in accordance with law, we were acting bona fide and good faith, and even under the Companies Act, they would probably be exonerated even if a prima facie breach was established. If, however, it does not have the force of law, then the question is, what is the sanctity of those directives in relation to the articles? Now, the articles are clearly a contract between shareholders and the company, and therefore any shareholder, including the petitioner in this case, would be bound by those articles. And if the particular shareholder has agreed that, look, he would be subject to the presidential directives, then in a sense he's contractually admitted and acknowledged his position and agreed to his position. So I think in that situation, then argue that those directives are completely non-binding would, to my mind, be very difficult. I think they would be binding, and it will be very interesting to see what view the court takes on it.
Once you have a public listed company, I don't think you can make the directors' actions subject to a directive by a majority shareholder. I doubt very much whether that will be valid under the Companies Act. Directors have a fiduciary duty, and they are bound to exercise their discretion.
Taking a similar line of argument, TCI has requested the Calcutta High Court to frame a scheme of management and administration for Coal India to grant perpetual injunction restraining government interference over 2 lakh crore rupee claim for Coal India for loss and damages suffered, over 9,000 crore rupee claim for TCI's losses, and an inquiry into loss incurred by Coal India due to breach of fiduciary duty by the board and shareholders' claim to this amount. First, a bilateral investment treaty notice, then a writ petition in the Delhi High Court, and now a representative or derivative suit in the Calcutta High Court. This one is expected to come up for hearing in the court next month. And experts tell me that a derivative suit of this nature is unprecedented in India's jurisprudence. TCI's fate aside, the result of this battle will answer 2 very important questions. The question of minority rights in a government-owned company, and the question of the role of the board and the discretion it should exercise while taking commercial decisions. Both the questions assume importance as the government seeks to divest its stake in various PSUs. We'll keep you posted on the answers.
In Mumbai, Payaswini Upadhyay.
As Payaswini says, watch this space for more, and I mean it literally, because right after this break, we'll be back with the latest CCI order.